Hello, my name's Paul Hughes, and I'm delighted to introduce what is going to be a series of webinars, podcasts, being led by my colleague Charles Whittington on behalf of the antitrust team of Steptoe and Johnson in Brussels. So what will we be covering in the series? We'll be looking at EU competition law as a powerful tool in the post-COVID business recovery phase. So competition law is a powerful tool that businesses can employ, hopefully in order to navigate their way through the current crisis. And we'll be trying to assist you to recover from the crisis using competition law as a pathway out. So we'll be reviewing a number of topics geared to those goals over the next few days and weeks. And this is the first of the various podcasts, Routes to Market in the New Normal, a twist of the competition law kaleidoscope. And we'll be providing an overview today on the potential routes to market in this new normal by highlighting what you can do with your distribution agreements and the benefits of those reviews and potentially removing redundant channel costs. So I'm a solicitor based in the Brussels office of Steptoe and Johnson. My name's Paul Hughes, and I've been advising on competition law for 30 years and have a strong focus on distribution and channel strategy. So that's the topic we're covering today. One of the issues we're going to look at is routes to market and the channel strategies that you may already have engaged in or potentially be looking at. And you'll obviously, as a business, be selecting channels and distribution arrangements that suit the geographic markets that you want to reach or maintain a presence in. And you'll be looking at those channels also from the point of view of the types of product and technology that you possess or might wish to possess in order to better penetrate the market. All the while taking into account that these channel strategies, both in their geographic and their product nature, need to satisfy the demands and expectations of end users, and that's a key element. All distribution strategy needs to be geared to the end user and their expectations, and those expectations are likely to have changed to some degree during the COVID-19 crisis. So we'll be reviewing those types of distribution arrangements by reference to the product life cycle. The product life cycle is the phase over time through which the distribution strategies have to navigate and the market changes that result from the earliest phase, which is pre-commercialization, when companies are contemplating entering the market, maybe developing new products or technologies through research and development programs, and potentially, as the owner of intellectual property, either the licensing of that to manufacturers for resale, or as a manufacturer without IP, potentially taking a license of intellectual property in order to penetrate and be present in the market. And typically, during the market entrance phase, a supplier, a manufacturer will need to look at strategies that enable the supplier to persuade early adopters to take up product. Perhaps it's a novel product or technology that's unfamiliar, the qualities of which need strong salesmanship. And in that regard, the manufacturer or supplier might be looking at, for example, selective distribution, highly qualified resellers who are best able to emphasize the qualities of the product, might be looking at exclusive distribution to incentivize resellers to take the product up, recognizing the need to invest in what is, after all, potentially a risky new product. And it's possible that at that point, the manufacturer or supplier will also need to have a think about the internet channels that they might use as they seek to penetrate the market. Might also be selling through an agent, although that's a sort of low-cost, tentative step into the market, or through OEM arrangements with manufacturers. Now, the As the market gains acceptance for the product, as end users begin to adopt it, market will grow for the relevant product. And as the market grows, so potentially those resale arrangements need to be revisited. And it may be that as the market matures and is saturated and is tipping towards decline, it was possible at that juncture that a supplier will want to, for instance, move to open supply if end users no longer value the product qualities in quite the same way they did when it was novel. As the market matures, it's possible concentration levels rise, and as it tips towards decline with demand falling away, a manufacturer might be tempted to engage in practices that are problematic from a computational point of view. So, for example, market foreclosing pricing practices, discrimination, range forcing, and so on, all of which could be potentially an abuse of a dominant position. Now, COVID-19 is likely to have accelerated this timeline and potentially chilled demand for product, so accelerating and calling for a fresh evaluation of channels on an expedited basis to see whether all of these are wholly compatible with the market as it's evolved. As a consequence, it may be, for example, that selective distribution, which was adopted in what was thought to be an early phase of the product life cycle, is now no longer the most suitable approach, not least because there is a limited capacity to sell through brick and mortar stores. And there's a further emphasis, obviously, in the current crisis on selling through internet channels. Internet channels can cannibalize or undermine selective distribution and can appear to be the least costly route to market, which will disincentivize, if the margins are eroded, reseller appetite for the product. So there may need to be a wholesale rethink of how you distribute at this point, with a greater emphasis on internet sales and a lesser emphasis on exclusive or selective distribution. Internet sales in particular have a very corrosive effect on exclusive distribution because of their long geographic reach. They tend to undermine the exclusivity, the territorial exclusivity that a distributor might otherwise enjoy. So channels may have been opted for distribution arrangements picked on the basis that there was a long life cycle ahead with demand increasing and ultimately particular forms of distribution being wholly suitable for the climate as it was thought to exist before COVID-19. And now there may be intense pressure, given the speeding up of the timeline, to consider to what degree demand has been chilled or rerouted through online channels. As regards R&D on the left-hand side of the chart, the current crisis may well mean that product launches are going to be delayed, R&D programs put on hold, or at least only those R&D programs pursued where the product is reaching close to market and the R&D is reaching fruition. With reference to EU competition law, which is obviously the focus of this talk, as well as the overview on strategic issues, I've put here on this particular slide some graphics which denote particular practices and the competition law consideration of those. So on the top left, I've got a reference to the IP owner potentially licensing. Licenses of IP are covered by the technology transfer block exemption regulation. We're not covering those. Equally, if the IP owner is at the R&D phase, that would be covered by the research and development block exemption. Both of these block exemptions are safe harbors from an EU competition law point of view. Again, I'm not dealing with those aspects today. The focus that I have is on the downward or vertical arrow relating to supply agreements. So on the assumption that the R&D has reached fruition, the IP has been licensed and the manufacturer is now in possession of the relevant IP or already owns it and is at the stage of supplying through resellers to the market, it's important to remember that the EU competition law provisions of the Treaty on the Functioning of the European Union, Article 101, divide particular restrictions into those which restrict by object and those which restrict by effect. So by object restrictions are presumed to be harmful to consumers, and I've listed them in very crude form down the left-hand side. So resale price maintenance, putting a floor under the reseller's price, minimum advertised prices, having a fixed or minimum price at which the reseller can advertise, total territorial exclusivity, export bans, or an internet ban. I've put nota bene agency because a true agent is someone on whom an upstream supplier can impose certain restrictions because they're integrated within the business, and those by object restrictions won't necessarily apply to the agency arrangements. With COVID-19 and perhaps selected distribution arrangements being stressed by the emphasis on internet sales, suppliers might be tempted to try and constrain or limit the activities of the internet channel by imposing minimum prices or by seeking to impose minimum online advertised prices. This would be a very dangerous tactic in which to engage. And whilst I wholly sympathise with a supplier who's finding that selective distribution is being wholly undermined by the internet and is seeing reseller margins eroded through emphasis on internet sales, it would be extremely unwise to engage in a by-object restriction because these are seen as ones that merit fines. It's also worth noting that one of the effects, anyway, of EU competition law is that anti-competitive restrictions are void and unenforceable. So moving to the effect-based restraints, it is, of course, permissible to have certain restrictions such as recommended resale prices, that's RRP in the graph, or exclusive territories, and to have quality-based criteria, selective distribution, for example, and franchising, and also to segment sales by reference to particular customers or product categories. So you indicate to your reseller that the reseller should focus on particular segments that you've allocated to them. The effects-based restraints are permissible where there's no significant foreclosure effects. So the foreclosure effects will be judged by reference to market definition, that's defining the product, that's the subject of the supply arrangements, both by reference to the geography in which conditions of competition are homogeneous, and also the substitutability of the product. Now, we will be doing a separate podcast on market definition, and I'm sure that these aspects will be covered in far more greater detail there. But it's very important to bear in mind that this effects-based analysis will wholly depend on those that definition analysis. And moving on to the next slide, you'll see the focus in this slide is on the effects, which are, crudely put, more pronounced, the more significant the market share that the upstream supplier and potentially the downstream reseller has. So territorial exclusivity, selective distribution, franchising, and so on, all those are within the vertical agreement safe harbor up to 30%. And for products in excess of the 30% threshold in the vertical agreement block exemption regulation, then the cap moves to, if you move beyond the cap, you have to do self-analysis, say, for example, if your market share is in the 30 to 40% category, to see whether there is an effect in the marketplace. And if you move to 50%, then there's a presumption that the relevant party has what's known as a dominant position, and the unilateral behavior of that party is then subject to Article 102 of the Treaty on the Functioning of the European Union, and if it engages in conduct which is deemed to be an abuse, for example, loyalty rebates are subject to analysis under Article 102, as is exclusivity, bundling, tying, price discrimination, refusals to deal, and so forth. With COVID-19, it's quite possible that market shares have been enhanced or destroyed by the very tumultuous change in the marketplace. So this is the twist in the kaleidoscope to which I referred in the title to this presentation. It's possible, for example, that if you're engaged in the production of protective personal equipment, your position in the market is now far stronger. The true definition of a dominant position is the capacity to act to an appreciable degree independently of competitors, customers, and ultimately the consumer. And the demand for PPE may be very strong, and the number of suppliers may be very few. It may be extremely difficult to obtain supplies, and prices may edge up. All that would be indicative, for example, of potential dominance in the field. And it may be that you have supply arrangements that include restrictions that are now potentially subject to analysis as abusive practices under Article 102. Conversely, companies that thought they had extremely strong market presence may have seen those that particular share destroyed or chilled by the market changes. It may be that, irrespective of the type of product, particular competitors have been forced to leave the field, and therefore the remaining players are now cloaked with greater market share, and potentially their arrangements have a foreclosing effect or indeed shade into dominance. So it could be that it's good news from a commercial point of view, but bad news from a competitional point of view, in that you're now subject to greater scrutiny. On the other hand, it may be that what was once a very powerful position has now been reduced to a powerless one. And I suppose the sort of good news, if there is any, is that you might be able now to engage in different practices and to operate supply arrangements where there's minimal effect in the marketplace and will be subject to less competition scrutiny. Or whether you can actually do that at this stage is another matter. Because we're now going to move to a further slide which talks about the strategic realignment in which you might need to engage. So all channel strategies effectively are trying to create value. They're trying to produce a return on the investments that have been made both by the supplier and the reseller. And it's clearly important for suppliers at this point to consider whether they have redundant channel arrangements. So they might be lumping costs onto selected distributors that are obviously inappropriate and unnecessary. Maybe they need to move to open supply because of this telescoped effect, this acceleration in the timeline, and the need to reconsider perhaps a focus on internet sales. So a supplier will need to reconsider its distribution arrangements and retune the channels, maybe temporarily, maybe on a more protracted basis. It's also possible to try and preserve your selective distribution arrangements, for instance, by ensuring that the online channel, the internet reseller, adheres to the selective distribution criteria that you imposed on the brick and mortar stores and which are now no longer functioning. So the need for realignment, as we saw when we looked at the product life cycle, moving from early adoption to market take-up to market maturity and then decline, led the supplier to reconsider moving from more hands-on, more prescriptive arrangements such as exclusive and selective distribution to open distribution. And now the COVID-19 crisis has created a shorter timeline, a more accelerated, perhaps V-shaped rather than a gentle S-shaped curve of the type that I depicted, and the review will therefore need to take place having regard to this very different landscape that the supplier is considering. So as Bob Wills said, time changes everything, and we can only hope, as he also hoped, that the clouds will roll away and the blue skies will emerge, but it will be on a different landscape, and that calls for different channel strategies. It's fine for me to advocate maybe reviewing your channel strategies. As Jimi Hendrix said, there must be some kind of way out of here, and the issue is, can you do it? Because you've obviously got contractual arrangements. These contractual arrangements have clear provisions that might, for example, impose long notice periods or have fixed periods. So it'll be difficult perhaps to reconfigure them. On the other hand, it may be that they contain provisions relating to minimum volumes, market penetration requirements, and those targets might not have been met. So there may be short notice periods, and the possibility of evolving or reshaping your channel strategy might also be contractually permissible. On the other hand, there might be force majeure clauses that suspend some of these obligations and make it hard to trigger a default and to choose a different path. All suppliers will be sensitive to the need to continue to maintain a presence in the market and will be very cautious about trying to terminate or reshape the reseller arrangement. So clearly dialogue is important, and reaching some consensual arrangement is the best. As I mentioned earlier, competition law is both a sword and a shield. So for those who have found the landscape changed, it may be the diminished market share offers them a shield. On the other hand, if a rival has suddenly acquired a very significant market position and is engaging in market foreclosing strategies, then perhaps competition law can be used as a sword to attack the particular practices that have been adopted. And a final sad note on which to end, as you'll know from my accent, I'm British, and of course Britain is leaving Europe. There will be a need to reconsider some of these arrangements in light of Brexit. It's a topic beyond this particular presentation. For overseas suppliers currently in the European market who are thinking perhaps of rolling up the map and returning home, it will be important to still have some presence in Europe, I'm sure, and that will lead to a more profound reevaluation of their channel strategies. Perhaps remote sales through the internet, maybe using a light presence such as agency to maintain some presence, some profile with the market. Those are very difficult decisions to take and will require, as I say, a more radical reevaluation of the arrangements that need to be put in place. And on that note, I conclude, and again, we just say stay tuned for the next video update, and thank you very much indeed for joining me today. And I would also stress that Charles is spearheading this particular program, and he will be introducing a number of additional topics, which I'm sure will be of interest to you all. Thank you.